Scheduled and tribal areas. Article 244 in Part X of the Constitution envisages a special system of administration for certain areas designated as scheduled areas and tribal areas. The fifth schedule of the Constitution deals with the administration and control of scheduled areas and scheduled tribes in any state except the four states of Assam, Meghalaya, Tripura and Mizoram. 1. The sixth schedule of the Constitution, on the other hand, deals with the administration of the tribal areas in the four northeastern states of Assam, Meghalaya, Tripura and Mizoram. Administration of scheduled areas. The scheduled areas are treated differently from the other areas in the country because they are inhabited by aboriginals, who are socially and economically rather backward, and special efforts need to be made to improve their condition. Therefore, the whole of the normal administrative machinery operating in a state is not extended to the scheduled areas, and the central government has somewhat greater responsibility for these areas too. The various features of administration contained in the fifth schedule are as follows. 1. Declaration of scheduled areas. The President is empowered to declare an area to be a scheduled area. He can also increase or decrease its area. Alter its boundary lines, rescind such designation or make fresh orders for such redesignation on an area in consultation with the governor of the state concerned. 2. Executive power of state and center. The executive power of a state extends to the scheduled areas therein. But the governor has a special responsibility regarding such areas. He has to submit a report to the President regarding the administration of such areas, annually or whenever so required by the President. The executive power of the center extends to giving directions to the states regarding the administration of such areas. 3. Tribes Advisory Council. Each state having scheduled areas has to establish a Tribes Advisory Council to advise on welfare and advancement of the scheduled tribes. It is to consist of 20 members, 3/4 of whom are to be the representatives of the scheduled tribes in the state legislative assembly. A similar council can also be established in a state having scheduled tribes but not scheduled areas therein, if the President so directs. 4. Law applicable to scheduled areas. The governor is empowered to direct that any particular act of parliament or the state legislature does not apply to a scheduled area or apply with specified modifications and exceptions. He can also make regulations for the peace and good government of a scheduled area after consulting the Tribes Advisory Council. Such regulations may prohibit or restrict the transfer of land by or among members of the scheduled tribes, regulate the allotment of land to members of the scheduled tribes and regulate the business of money lending in relation to the scheduled tribes. Also, a regulation may repeal or amend any act of parliament or the state legislature, which is applicable to a scheduled area. But, all such regulations require the assent of the President. The Constitution requires the President to appoint a commission to report on the administration of the scheduled areas and the welfare of the scheduled tribes in the states. He can appoint such a commission at any time but compulsorily after 10 years of the commencement of the Constitution. Hence, a commission was appointed in 1960. It was headed by UN Weber and submitted its report in 1961. After 4 decades, the second commission was appointed in 2002 under the chairmanship of Dilip Singh Bhuria. It submitted its report in 2004. Administration of Tribal Areas. The Constitution, under 6th Schedule, contains special provisions for the administration of tribal areas in the 4 northeastern states of Assam, Meghalaya, Tripura and Mizoram. The rationality behind the special arrangements in respect of only these 4 states lies in the following. The tribes in Assam, Meghalaya, Tripura and Mizoram have not assimilated much the life and ways of the other people in these states. These areas have hitherto been anthropological specimens. The tribal people in other parts of India have more or less adopted the culture of the majority of the people in whose midst they live. The tribes in Assam, Meghalaya, Tripura and Mizoram, on the other hand, still have their roots in their own culture, customs and civilization. These areas are, therefore,
treated differently by the Constitution, and sizable amount of autonomy has been given to these people for self-government. 3. The various features of administration contained in the 6th schedule are as follows. 1. The tribal areas in the 4 states of Assam, Meghalaya, Tripura and Mizoram have been constituted as autonomous districts. 4. But they do not fall outside the executive authority of the state concerned. 2. The governor is empowered to organize and reorganize the autonomous districts. Thus, he can increase or decrease their areas or change their names or define their boundaries and so on. 3. If there are different tribes in an autonomous district, the governor can divide the district into several autonomous regions. 4. Each autonomous district has a district council consisting of 30 members, of whom 4 are nominated by the governor and the remaining 26 are elected on the basis of adult franchise. The elected members hold office for a term of 5 years, unless the council is dissolved earlier, and nominated members hold office during the pleasure of the governor. Each autonomous region also has a separate regional council. 5. The district and regional councils administer the areas under their jurisdiction. They can make laws on certain specified matters like land, forests,
canal water, shifting cultivation, village administration, inheritance of property, marriage and divorce, social customs and so on. But all such laws require the assent of the governor. 6. The district and regional councils within their territorial jurisdictions can constitute village councils or courts for trial of suits and cases between the tribes. They hear appeals from them. The jurisdiction of High Court over these suits and cases is specified by the governor. 7. The district council can establish, construct or manage primary schools, dispensaries, markets, ferries, fisheries, roads and so on in the district. It can also make regulations for the control of money lending and trading by non-TRVBILS. But such regulations require the assent of the governor. 8. The district and regional councils are empowered to assess and collect land revenue and to impose certain specified taxes. 9. The Acts of Parliament or the state legislature do not apply to autonomous districts and autonomous regions or apply with specified modifications and exceptions. 5. 10. The governor can appoint a commission to examine and report on any matter relating to the administration of the autonomous districts or regions. He may dissolve a district or regional council on the recommendation of the commission. Table 41.1 Tribal Areas at a Glance, 2016, States Tribal Areas. 1. The North Kutch Hills District. 1. Assam. 2. The Karbi Anglong District. 3. The Bodoland Territorial Areas District. 1. Khasi Hills District. 2. Meghalaya. 2. Genchia Hills District. 3. The Garo Hills District. 3. Tripura Tribal Areas District. 1. The Chakma District. 4. Mizoram. 2. The Mara District. 3. The Lair District. Table 41.2 Articles related to scheduled and tribal areas at a glance. Article No. Subject Matter 244. Administration of scheduled areas and tribal areas. 244A. Formation of an autonomous state comprising certain tribal areas in Assam and creation of local legislature or council of ministers or both. Therefore 339. Control of the Union over the administration of scheduled areas and the welfare of scheduled tribes. Table 41.3 Orders relating to scheduled areas, 2016, 6s. No. Name of order, name of state, S, for which applicable. 1. The scheduled areas, Part A States, Order, 1950 Andhra Pradesh and Telangana. 2. The scheduled areas, Part B States, Order, 1950 Andhra Pradesh and Telangana. 3. The scheduled areas, Himachal Pradesh, Order, 1975 Himachal Pradesh. 4. The scheduled areas, States of Bihar, Gujarat, Madhya Pradesh and Orissa, Order, 1977 Gujarat and Odisha. 5. The scheduled areas, State of Rajasthan, Order, 1981 Rajasthan. 6. The scheduled areas, Maharashtra, Order, 1985 Maharashtra 7. The scheduled areas, states of Chhattisgarh, Jharkhand and Madhya Pradesh, Order, 2003 Chhattisgarh and Madhya Pradesh.
The scheduled areas.
State of Jharkhand, Order, 2007 Jharkhand. Note, the states of Madhya Pradesh and Bihar were reorganized via the Madhya Pradesh Reorganization Act, 2000 and Bihar Reorganization Act, 2000 respectively. Consequently, a portion of scheduled areas of the composite state of Madhya Pradesh stood transferred to the newly formed state of Chhattisgarh, and the whole of scheduled areas stood transferred to Jharkhand from the parent state of Bihar. Hence, it became necessary to amend the scheduled areas, states of Bihar, Gujarat, Madhya Pradesh and Orissa, Order, 1977 insofar as it related to the composite states of Bihar and Madhya Pradesh. The President has promulgated a new constitutional order specifying the scheduled areas in respect of the states of Chhattisgarh, Jharkhand and Madhya Pradesh in 2003. The scheduled areas in the state of Jharkhand have been redefined to be the scheduled areas within the state of Jharkhand via the scheduled areas, State of Jharkhand, Order, 2007.7 Notes and References 1. At present, 2016, 10 states of India have scheduled areas. These are Andhra Pradesh, Telangana, Jharkhand, Chhattisgarh, Gujarat, Himachal Pradesh, Madhya Pradesh, Maharashtra, Odisha and Rajasthan. To MP Jain, Indian Constitutional Law, Wadhwa, 4th edition, 1987, p. 236. 3 Ibid, p. 237. For presently, 2016, there are a total of 10 tribal areas. See Table 41.1. 5. The power of direction, in this regard, lies either with the President or Governor. Thus, in the case of Assam, it lies with the Governor, both in respect of Acts of Parliament or State Legislature. In the case of Meghalaya, Tripura and Mizoram, it lies with the President in respect of Acts of Parliament and Governor in respect of Acts of State Legislature. 6. Annual Report 2015-16, Ministry of Tribal Affairs, Government of India pp. 33-34. 7 Ibid. Part 7 Constitutional Bodies 42. Election Commission 43. Union Public Service Commission 44. State Public Service Commission 45. Finance Commission 46. National Commission for STs 47. National Commission for STs 48. Special Officer for Linguistic Minorities 49. Controller and Auditor General of India 50. Attorney General of India 51. Advocate General of the State. Election Commission. The Election Commission is a permanent and an independent body established by the Constitution of India directly to ensure free and fair elections in the country. Article 324 of the Constitution provides that the power of superintendence, direction and control of elections to Parliament, state legislatures, the office of President of India and the office of Vice President of India shall be vested in the Election Commission. Thus, the Election Commission is an all-India body in the sense that it is common to both the central government and the state governments. It must be noted here that the Election Commission is not concerned with the elections to panchayats and municipalities in the states. For this, the Constitution of India provides for a separate State Election Commission. 1. Composition. Article 324 of the Constitution has made the following provisions with regard to the composition of Election Commission. 1. The Election Commission shall consist of the Chief Election Commissioner and such number of other election commissioners, if any, as the President may from time to time fix. 2. The appointment of the Chief Election Commissioner and other election commissioners shall be made by the President. 3. When any other election commissioner is so appointed, the Chief Election
Commissioner shall act as the
the
chairman
chairman of the Election Commission. 4. The President may also appoint after consultation with the
Election
Election
Commission
Commission
such
such regional commissioners as he may consider necessary to assist the Election Commission. 5. The conditions of service and tenure of office of the Election Commissioners and the Regional Commissioners shall be determined by the President. Since its inception in 1950 until 15 October 1989, the Election Commission functioned as a single-member body consisting of the Chief Election Commissioner. On 16 October 1989, the President appointed 2 more election commissioners to cope with the increased work of the Election Commission on account of lowering of the voting age from 21 to 18 years. 2. Thereafter, the Election Commission functioned as a multi-member body consisting of 3 election commissioners. However, the 2 posts of election commissioners were abolished in January 1990 and the Election Commission was reverted to the earlier position. Again in October 1993, the President appointed 2 more election commissioners. Since then until today, the Election Commission has been functioning as a multi-member body consisting of 3 election commissioners. The Chief Election Commissioner and the 2 other election commissioners have equal powers and receive equal salary, allowances and other perquisites, which are similar to those of a judge of the Supreme Court. 3. In case of difference of opinion amongst the Chief Election Commissioner and or 2 other election commissioners, the matter is decided by the Commission by majority. They hold office for a term of 6 years or until they attain the age of 65 years, whichever is earlier. They can resign at any time or can also be removed before the expiry of their term. Independence Article 324 of the Constitution has made the following provisions to safeguard and ensure the independent and impartial functioning of the Election Commission. 1. The Chief Election Commissioner is provided with the security of tenure.
He cannot
be removed from his office except in same manner and on the same grounds as a judge of the Supreme Court. In other words, he can be removed by the President on the basis of a resolution passed to that effect by both the Houses of Parliament with special majority, either on the ground of proved misbehavior or incapacity. Thus, he does not hold his office till the pleasure of the President, though he is appointed by him. 2. The service conditions of the Chief Election Commissioner cannot be varied to his disadvantage after his appointment. 3. Any other election commissioner or a regional commissioner cannot be removed from office except on the recommendation of the Chief Election Commissioner. Though the Constitution has sought to safeguard and ensure the independence and impartiality of the Election Commission, some flaws can be noted, viz. 1. The Constitution has not prescribed the qualifications, legal, educational, administrative or judicial, of the members of the Election Commission. 2. The Constitution has not specified the term of the members of the Election Commission. 3. The Constitution has not debarred the retiring election commissioners from any further appointment by the government. Powers and functions. The powers and functions of the Election Commission with regard to elections to the Parliament, state legislatures and offices of President and Vice President can be classified into 3 categories, viz. 1. Administrative. 2. Advisory. 3. Quasi-judicial. In detail, these powers and functions are: 1. To determine the territorial areas of the electoral constituencies throughout the country on the basis of the Delimitation Commission Act of Parliament. 4. 2. To prepare and periodically revise electoral rolls and to register all eligible voters.
To notify
the dates and schedules of elections and to scrutinize nomination papers. 4. To grant recognition to political parties and allot election symbols to them. 5. To act as a court for settling disputes related to granting of recognition to political parties and allotment of election symbols to them. 6. To appoint officers for inquiring into disputes relating to electoral arrangements. 7. To determine the code of conduct to be observed by the parties and the candidates at the time of elections. 8. To prepare a roster for publicity of the policies of the political parties on radio and TV in times of elections. 9. To advise the President on matters relating to the disqualifications of the members of Parliament. 10. To advise the governor on matters relating to the disqualifications of the members of state legislature. 11. To cancel polls in the event of rigging, booth capturing, violence and other irregularities. 12. To request the president or the governor for requisitioning the staff necessary for conducting elections. 13. To supervise the machinery of elections throughout the country to ensure free and fair elections. 14. To advise the president whether elections can be held in a state under president's rule in order to extend the period of emergency after 1 year. 15. To register political parties for the purpose of elections and grant them the status of national or state parties on the basis of their poll performance. 5. The Election Commission is assisted by Deputy Election Commissioners. They are drawn from the civil service and appointed by the Commission with tenure system. They are assisted, in turn, by the Secretaries, Joint Secretaries, Deputy Secretaries and Under Secretaries posted in the Secretariat of the Commission. At the state level, the Election Commission is assisted by the Chief Electoral Officer who is appointed by the Chief Election Commissioner in consultation with the state government. Below this, at the district level, the collector acts as the district returning officer. He appoints a returning officer.
For every
constituency in the district and presiding officer for every polling booth in the constituency. Vision, mission and principles. 6. Vision. The Election Commission of India strives to be an institution of excellence by enhancing active engagement, participation, and deepening and strengthening electoral democracy in India and globally. Mission. The Election Commission of India maintains independence, integrity and autonomy, ensures accessibility, inclusiveness, and ethical participation of stakeholders, and adopts highest standards of professionalism for delivering free, fair, and transparent elections to strengthen the trust in electoral democracy and governance. Guiding principles. The Commission has laid down for itself guiding principles of good governance. 1. To uphold the values enshrined in the Constitution viz. Equality, equity, impartiality, independence, and rule of law in superintendence, direction and control over the electoral governance. 2. To conduct elections with highest standard of credibility, freeness, fairness, transparency, integrity, accountability, autonomy and professionalism. 3. To ensure participation of all eligible citizens in the electoral process in an inclusive, voter-centric and voter-friendly environment. 4. To engage with political parties and all stakeholders in the interest of electoral process. 5. To promote awareness about the electoral process and electoral governance amongst stakeholders, namely, voters, political parties, election functionaries, candidates and people at large, and to enhance and strengthen confidence and trust in the electoral system of this country. 6. To develop the human resource for effective and professional delivery of electoral services. 7. To build quality infrastructure for smooth conduct of electoral process. 8. To adopt technology for improvement in all areas of electoral process.
9.
To
To
strive
strive
for adoption of innovative practices for achieving excellence and overall realization of the vision and mission. 10. To contribute towards the reinforcement of democratic values by maintaining and reinforcing confidence and trust of the people in the electoral system of the country. Notes and references. 1. Wide 73rd and 74th Constitutional Amendment Acts of 1992. 2. By the 61st Constitutional Amendment Act of 1988, which came into force in 1989. 3. In 2009, the salary of a judge of the Supreme Court had been fixed at 90,000 per month. 4. The Parliament has made the Delimitation Commission Acts in 1952, 1962, 1972 and 2002. 5. For details in this regard, see Chapter 67, Political Parties. 6. Strategic Plan 2016 to 2025, Election Commission of India, pp. 8 to 9.
Union Public Service Commission.
Union Public Service Commission, UPSC, is the central recruiting agency in India. It is an independent constitutional body in the sense that it has been directly created by the Constitution. Articles 315 to 323 in Part 14 of the Constitution contain elaborate provisions regarding the composition, appointment and removal of members along with the independence, powers and functions of the UPSC. Composition: the UPSC consists of a chairman and other members appointed by the President of India. The Constitution, without specifying the strength of the Commission, has left the matter to the discretion of the President, who determines its composition. Usually, the Commission consists of 9 to 11 members including the chairman. Further, no qualifications are prescribed for the Commission's membership except that one half of the members of the Commission should be such persons who have held office for at least 10 years either under the Government of India or under the government of a state. The Constitution also authorizes the President to determine the conditions of service of the chairman and other members of the Commission.
The chairman and members of the
Commission hold office for a term of 6 years or until they attain the age of 65 years, whichever is earlier. However, they can relinquish their offices at any time by addressing their resignation to the President. They can also be removed before the expiry of their term by the President in the manner as provided in the Constitution. The President can appoint one of the members of the UPSC as an acting chairman in the following two circumstances: 1. A. When the office of the chairman falls vacant, or B. When the chairman is unable to perform his functions due to absence or some other reason. The acting chairman functions till a person appointed as chairman enters on the duties of the office or till the chairman is able to resume his duties. Removal: the President can remove the chairman or any other member of UPSC from the office under the following circumstances: A. If he is adjudged an insolvent, that is, has gone bankrupt. B. If he engages, during his term of office, in any paid employment outside the duties of his office, or C. If he is, in the opinion of the President, unfit to continue in office by reason of infirmity of mind or body. In addition to these, the President can also remove the chairman or any other member of UPSC for misbehavior. However, in this case, the President has to refer the matter to the Supreme Court for an enquiry. If the Supreme Court, after the enquiry, upholds the cause of removal and advises so, the President can remove the chairman or a member. Under the provisions of the Constitution, the advice tendered by the Supreme Court in this regard is binding on the President. During the course of enquiry by the Supreme Court, the President can suspend the chairman or the member of UPSC. Defining the term misbehavior, in this context, the Constitution states that the chairman or any other member of the UPSC is deemed to be guilty of misbehavior if he A. is concerned or interested in any contract or agreement made by the Government of India or the government of a state, or B. participates in any way in the profit of such contract or agreement or in any benefit therefrom otherwise than as a member and in common with other members of an incorporated company. Independence: the Constitution has made the following provisions to safeguard and ensure the independent and impartial functioning of the UPSC. The chairman or a member of the UPSC can be removed from office by the President only in the manner and on the grounds mentioned in the Constitution. Therefore, they enjoy a security of tenure. B. The conditions of service of the chairman or a member, though determined by the President, cannot be varied to his disadvantage after his appointment. C. The entire expenses including the salaries, allowances and pensions of the chairman and members of the UPSC are charged on the Consolidated Fund of India. Thus, they are not subject to vote of Parliament. D. The chairman of UPSC, on ceasing to hold office, is not eligible for further employment in the Government of India or a state too. E. A member of UPSC, on ceasing to hold office, is eligible for appointment as the chairman of UPSC or a state public service commission, SPSC, but not for any other employment in the Government of India or a state 3. F. The chairman or a member of UPSC is, after having completed his first term, not eligible for reappointment to that office, i.e., not eligible for second term. Functions: the UPSC performs the following functions. A. It conducts examinations for appointments to the All India services. central services and public services of the centrally administered territories. B. It assists the states, if requested by two or more states to do so, in framing and operating schemes of joint recruitment for any services for which candidates possessing special qualifications are required. C. It serves all or any of the needs of a state on the request of the state.
Governor and with the
approval
approval
of the President of India. D. It is consulted on the following matters related to personnel management. I. All matters relating to methods of recruitment to civil services and for civil posts. 2. The principles to be followed in making appointments to civil services and posts and in making promotions and transfers from one service to another. 3. The suitability of candidates for appointments to civil services and posts, for promotions and transfers from one service to another, and appointments by transfer or deputation. The concerned departments make recommendations for promotions and request the UPSC to ratify them. 4. All disciplinary matters affecting a person serving under the Government of India in a civil capacity, including memorials or petitions relating to such matters. These include censure, severe disapproval, withholding of increments, withholding of promotions, recovery of pecuniary loss, reduction to lower service or rank, demotion, compulsory retirement, removal from service, dismissal from service. 4. Any claim for reimbursement of legal expenses incurred by a civil servant in defending legal proceedings instituted against him in respect of acts done in the execution of his official duties. 6. Any claim for the award of a pension in respect of injuries sustained by a person while serving under the Government of India and any question as to the amount of any such award. 7. Matters of temporary appointments for period exceeding 1 year and on regularization of appointments. 8. Matters related to grant of extension of service and re-employment of certain retired civil servants. 9. Any other matter related to personnel management. The Supreme Court has held that if the government fails to consult UPSC
in the matters mentioned above,
the aggrieved public servant has no remedy in a court. In other words, the court held that any irregularity in consultation with the UPSC or acting without consultation does not invalidate the decision of the government. Thus, the provision is directory and not mandatory. Similarly, the court held that a selection by the UPSC does not confer any right to the post upon the candidate. However, the government is to act fairly and without arbitrariness or malefice. The additional functions relating to the services of the Union can be conferred on UPSC by the Parliament. It can also place the personnel system of any authority, corporate body or public institution within the jurisdiction of the UPSC. Hence, the jurisdiction of UPSC can be extended by an act made by the Parliament. The UPSC presents, annually, to the President a report on its performance. The President places this report before both the Houses of Parliament, along with a memorandum explaining the cases where the advice of the Commission was not accepted and the reasons for such non-acceptance. All such cases of non-acceptance must be approved by the Appointments Committee of the Union Cabinet. An individual ministry or department has no power to reject the advice of the UPSC. Limitations: the following matters are kept outside the functional jurisdiction of the UPSC. In other words, the UPSC is not consulted on the following matters: a. While making reservations of appointments or posts in favor of any backward class of citizens. b. While taking into consideration the claims of scheduled castes and scheduled tribes in making appointments to services and posts. c. With regard to the selections for chairmanship or membership of commissions or tribunals, posts of the highest diplomatic nature and a bulk of Group C and Group D services. d. With regard to the selection for temporary or officiating appointment to a post if the person appointed is not likely to hold the post for more than a year. The President can exclude posts, services and matters from the purview of
the UPSC.
The Constitution states that the President, in respect to the All India services and central services and posts, may make regulations specifying the matters in which it shall not be necessary for UPSC to be consulted. But all such regulations made by the President shall be laid before each House of Parliament for at least 14 days. The Parliament can amend or repeal them. Role: the Constitution visualizes the UPSC to be the watchdog of merit system in India. It is concerned with the recruitment to the All India Services and Central Services, Group A and Group B, and advises the government, when consulted, on promotion and disciplinary matters. It is not concerned with the classification of services, pay and service conditions, cadre management, training, and so on. These matters are handled by the Department of Personnel and Training, one of the three departments of the Ministry of Personnel, Public Grievances and Pensions 5. Therefore, UPSC is only a central recruiting agency, while the Department of Personnel and Training is the central personnel agency in India. The role of UPSC is not only limited, but also recommendations made by it are only of advisory nature and hence, not binding on the government. It is up to the Union government to accept or reject that advice. The only safeguard is the answerability of the government to the Parliament for departing from the recommendation of the Commission. Further, the government can also make rules which regulate the scope of the advisory functions of UPSC 6. The emergence of Central Vigilance Commission, CVC, in 1964 affected the role of UPSC in disciplinary matters. This is because both are consulted by the government while taking disciplinary action against a civil servant. The problem arises when the two bodies tender conflicting advice. However, the UPSC, being an independent constitutional body, has an edge over the CVC, which is created by an executive resolution of the Government of India and conferred a statutory status in October 2003. Table 43.1 Articles related to UPSC at a glance.
Article No.
Subject matter 315 Public Service Commissions for the Union and for the States, 316 Appointment and term of office of members, 317 Removal and suspension of a member of a Public Service Commission, 318 Power to make regulations as to conditions of service of members and staff of the Commission, 319 Prohibition as to the holding of office by members of Commission on ceasing to be such members, 320 Functions of Public Service Commissions, 321 Power to extend functions of Public Service Commissions, 322 Expenses of Public Service Commissions, 323 Reports of Public Service Commissions, Notes and References 1. Added by the 15th Amendment Act of 1963. 2. In 1979, the Supreme Court upheld the validity of appointment of A.R. Kidwai, a former chairman of UPSC, as the Governor of Bihar. It ruled that the office of the governor is a constitutional office, and not an employment under the government. 3. When a member of UPSC is appointed as its chairman, he holds the new office for 6 years or until the age of superannuation, whichever is earlier. 4. The difference between removal and dismissal is that the former does not disqualify for future employment under the government, while the latter disqualifies for future employment under the government. 5. In 1985, a new full-fledged Ministry of Personnel, Public Grievances and Pensions was created with 3 separate departments. These are Department of Personnel and Training, Department of Administrative Reforms and Public Grievances, and Department of Pensions and Pensioners' Welfare. 6 such rules are known as the UPSC, Exemption from Consultation, Regulations.
State
Public Service Commission parallel to the Union Public Service Commission, UPSC. At the center, there is a State Public Service Commission, SPSC, in a state. The same P set of articles, i.e., 315 to 323 in Part 14 of the Constitution also deal with the composition, appointment and removal of members, power and functions and independence of a SPSC. Composition: a State Public Service Commission consists of a chairman and other members appointed by the governor of the state. The Constitution does not specify the strength of the commission but has left the matter to the discretion of the governor. Further, No qualifications are prescribed for the Commission's membership except that one half of the members of the Commission should be such persons who have held office for at least 10 years either under the Government of India or under the government of a state. The Constitution also authorizes the Governor to determine the conditions of service of the Chairman and members of the Commission. The Chairman and members of the Commission hold office for a term of 6 years or until they attain the age of 62 years 1, whichever is earlier. In the case of UPSC, the age limit is 65 years. However, they can relinquish their offices at any time by addressing their resignation to the Governor. The Governor can appoint one of the members of the SPSC as an acting
Chairman in the following two
circumstances to a. When the office of the Chairman falls vacant, or b. When the Chairman is unable to perform his functions due to absence or some other reason. The acting Chairman functions till the person appointed as Chairman enters on the duties of the office or till the Chairman is able to resume his duties. Removal of the Chairman and members of a SPSC are appointed by the Governor. They can be removed only by the President, and not by the Governor. The President can remove them on the same grounds and in the same manner as he can remove a Chairman or a member of the UPSC. Thus, he can remove him under the following circumstances: a. If he is adjudged an insolvent, i.e., has gone bankrupt, or b. If he engages, during his term of office, in any paid employment outside the duties of his office, or c. If he is, in the opinion of the President, unfit to continue in office by reason of infirmity of mind or body. 3. In addition to these, the President can also remove the Chairman or any other member of SPSC for misbehavior. However, in this case, the President has to refer the matter to the Supreme Court for an enquiry. If the Supreme Court, after the enquiry, upholds the cause of removal and advises so, the President can remove the Chairman or a member. Under the provisions of the Constitution, the advice tendered by the Supreme Court in this regard is binding on the President. However, during the course of enquiry by the Supreme Court, the Governor can suspend the concerned Chairman or member, pending the final removal order of the President on receipt of the report of the Supreme Court. Further, the Constitution has also defined the term misbehavior in this context. The Constitution states that the Chairman or any other member of a SPSC is deemed to be guilty of misbehavior if he, a. is concerned or interested in any contract or agreement made by the Government of India or the Government of a state, or b. participates in any way in the profit of such contract or agreement or in any benefit therefrom otherwise than as a member. And in common with other members of an incorporated company. Independent as in the case of UPSC,
the Constitution has
made the following provisions to safeguard and ensure the independent and impartial functioning of a SPSC. The Chairman or a member of a SPSC can be removed from office by the President only in the manner and on the grounds mentioned in the Constitution. Therefore, they enjoy the security of tenure. b. The conditions of service of the Chairman or a member, though determined by the Governor, cannot be varied to his disadvantage after his appointment. c. The entire expense including the salaries, allowances and pensions of the Chairman and members of a SPSC are charged on the consolidated fund of the state. Thus, they are not subject to vote of the state legislature. d. The Chairman of a SPSC, on ceasing to hold office, is eligible for appointment as the Chairman or a member of the UPSC or as the Chairman of any other SPSC, but not for any other employment under the Government of India or a state. e. A member of a SPSC, on ceasing to hold office, is eligible for appointment as the Chairman or a member of the UPSC, or as the Chairman of that SPSC or any other SPSC, but not for any other employment under the Government of India or a state. f. The Chairman or a member of a SPSC is, after having completed his first term, not eligible for reappointment to that office, that is, not eligible for second term. Functions a SPSC performs all those functions in respect of the state services as the UPSC does in relation to the central services. a. It conducts examinations for appointments to the services of the state. b. It is consulted on the following matters related to personnel management, I. All matters relating to methods of recruitment to civil services and for civil posts.
2. The principles to be followed
in making appointments to civil services and posts and in making promotions and transfers from one service to another. 3. The suitability of candidates for appointments to civil services and posts, for promotions and transfers from one service to another, and appointments by transfer or deputation. The concerned departments make recommendations for promotions and request the SPSC to ratify them. 4. All disciplinary matters affecting a person serving under the government of the state in a civil capacity, including memorials or petitions relating to such matters. These include censure, severe disapproval, withholding of increments, withholding of promotions, recovery of pecuniary loss, reduction to lower service or rank, demotion, compulsory retirement, removal from service, dismissal from service. 4. Any claim for reimbursement of legal expenses incurred by a civil servant in defending legal proceedings instituted against him in respect of acts done in the execution of his official duties. 6. Any claim for the award of a pension in respect of injuries sustained by a person while serving under the government of the state and any question as to the amount of any such award. 7. Any other matter related to the personnel management. The Supreme Court has held that if the government fails to consult the SPSC in these matters, the aggrieved public servant has no remedy in a court. In other words, the court held that any irregularity in consultation with the SPSC or acting without consultation does not invalidate the decision of the government. Thus, the provision is directory and not mandatory. Similarly, the court held that a selection by the SPSC does not confer any right to the post upon the candidate. However, the government is to act fairly and without arbitrariness or malefice. The additional functions relating to the services of the state can be conferred on SPSC by the state legislature. It can also place the personnel system of any local authority, corporate body or public institution
within the jurisdiction of the
SPSC. Hence, the jurisdiction of SPSC can be extended by an act made by the state legislature. The SPSC presents, annually, to the governor a report on its performance. The governor places this report before both the houses of the state legislature, along with a memorandum explaining the cases where the advice of the commission was not accepted and the reasons for such non-acceptance. Limitations: the following matters are kept outside the functional jurisdiction of the SPSC. In other words, the SPSC is not consulted on the following matters: a. While making reservations of appointments or posts in favor of any backward class of citizens. b. While taking into consideration the claims of scheduled castes and scheduled tribes in making appointments to services and posts. The governor can exclude posts, services and matters from the purview of the SPSC. The Constitution states that the governor, in respect to the state services and posts, may make regulations specifying the matters in which it shall not be necessary for SPSC to be consulted. But all such regulations made by the governor shall be laid before each house of the state legislature for at least 14 days. The state legislature can amend or repeal them. Role: the Constitution visualizes the SPSC to be the watchdog of merit system in the state. It is concerned with the recruitment to the state services and advises the government, when consulted, on promotion and disciplinary matters. It is not concerned with the classification of services, pay and service conditions, cadre management, training and so on. These matters are handled by the Department of Personnel or the General Administration Department. Therefore, the SPSC is only a central recruiting agency in the state, while the Department of Personnel or the General Administration Department is the
central
personnel agency in the state. The role of SPSC is not only limited, but also recommendations made by it are only of advisory nature and hence, not binding on the government. It is up to the state government to accept or reject that advice. The only safeguard is the answerability of the government to the state legislature for departing from the recommendation of the commission. Further, The government can also make rules which regulate the scope of the advisory functions of SPSC 5. Also, the emergence of State Vigilance Commission, SVC, in 1964 affected the role of SPSC in disciplinary matters. This is because both are consulted by the government while taking disciplinary action against a civil servant. The problem arises when the two bodies tender conflicting advice. However, the SPSC, being an independent constitutional body, has an edge over the SVC. Finally, the SPSC is consulted by the governor while framing rules for appointment to judicial service of the state other than the posts of district judges. In this regard, the concerned state high court is also consulted. Joint State Public Service Commission. The Constitution makes a provision for the establishment of a Joint State Public Service Commission, JSPSC, for two or more states. While the UPSC and the SPSC are created directly by the Constitution, a JSPSC can be created by an Act of Parliament on the request of the state legislatures concerned. Thus, a JSPSC is a statutory and not a constitutional body. The two states of Punjab and Haryana had a JSPSC for a short period, after the creation of Haryana out of Punjab in 1966. The chairman and members of a JSPSC are appointed by the President. They hold office for a term of 6 years or until they attain the age of 62 years, whichever is earlier. They can be suspended or removed by the President. They can also resign from their offices at any time by submitting their resignation letters to the President. The number of members of a JSPSC and their conditions of service are determined by the President. A JSPSC presents its annual performance report to each of the concerned
State
governors. Each governor places the report before the state legislature. The UPSC can also serve the needs of a state on the request of the state governor and with the approval of the President. As provided by the Government of India Act of 1919, a Central Public Service Commission was set up in 1926 and entrusted with the task of recruiting civil servants. The Government of India Act of 1935 provided for the establishment of not only a Federal Public Service Commission but also a Provincial Public Service Commission and Joint Public Service Commission for two or more provinces. Table 44.1 Articles related to SPSC at a glance. Article No. Subject matter 315 Public Service Commissions for the Union and for the States 316 Appointment and term of office of members 317 Removal and suspension of a member of a Public Service Commission 318 Power to make regulations as to conditions of service of members and staff of the Commission 319 Prohibition as to the holding of office by members of Commission on ceasing to be such members 320 Functions of Public Service Commissions 321 Power to extend functions of Public Service Commissions 322 Expenses of Public Service Commissions 323 Reports of Public Service Commissions Notes and References 1. Originally, it was 60 years. The 41st Amendment Act of 1976 raised it to 62 years. Added by the 15th Amendment Act of 1963. 3. In 1993, the Supreme Court ruled that appointment of a university professor, known to be blind, as a member of a SPSC cannot be set aside on the ground of infirmity of body or mind. For the difference between removal and dismissal is that the former does not disqualify for future employment under the government while the latter disqualifies for future employment under the government. 5 such rules are known as the SPSC, exemption from consultation, regulations. Finance Commission Article 280 of the Constitution of India provides for a Finance Commission as a quasi-judicial body. It is constituted by the President of India every 5th year or at such earlier time as he considers necessary. Composition: the Finance Commission consists of a chairman and 4 other members to be appointed by the President. They hold office for such period as specified by the President in his order. They are eligible for reappointment. The Constitution authorizes the Parliament to determine the qualifications of members of the Commission and the manner in which they should be selected. Accordingly, the Parliament has specified the qualifications of the Chairman and members of the Commission. 1. The chairman should be a person having experience in public affairs, and the 4 other members should be selected from amongst the following: 1. A judge of High Court or one qualified to be appointed as one. 2. A person who has specialized knowledge of finance and accounts of the government. 3. A person who has wide experience in financial matters and in administration. 4. A person who has special knowledge of economics.
Functions.
The Finance Commission is required to make recommendations to the President of India on the following matters. 1. The distribution of the net proceeds of taxes to be shared between the centre and the states, and the allocation between the states of the respective shares of such proceeds. 2. The principles that should govern the grants in aid to the states by the centre, i.e., out of the Consolidated Fund of India. 3. The measures needed to augment the consolidated fund of a state to supplement the resources of the panchayats and the municipalities in the state on the basis of the recommendations made by the State Finance Commission. 2. 4. Any other matter referred to it by the President in the interests of sound finance. Till 1960, the Commission also suggested the grants given to the states of Assam, Bihar, Odisha and West Bengal in lieu of assignment of any share of the net proceeds in each year of export duty on jute and jute products. These grants were to be given for a temporary period of 10 years from the commencement of the Constitution. The Commission submits its report to the President. He lays it before both the Houses of Parliament along with an explanatory memorandum as to the action taken on its recommendations. Advisory role. It must be clarified here that the recommendations made by the Finance Commission are only of advisory nature and hence, not binding on the government. It is up to the Union government to implement its recommendations on granting money to the states. To put it in other words, it is nowhere laid down in the Constitution that the recommendations of the Commission shall be binding upon the Government of India or that it would give rise to a legal right in favour of the beneficiary states to receive the money recommended to be offered to them by the Commission. 3.
As rightly observed by Dr. P. V.
Rajmanna, the chairman of the 4th Finance Commission, since the Finance Commission is a constitutional body expected to be quasi-judicial, its recommendations should not be turned down by the Government of India unless there are very compelling reasons. The Constitution of India envisages the Finance Commission as the balancing wheel of fiscal federalism in India. However, its role in the centre-state fiscal relations was undermined by the emergence of the erstwhile Planning Commission, a non-constitutional and a non-statutory body. Dr. P. V. Rajmanna, the chairman of the 4th Finance Commission, highlighted the overlapping of functions and responsibilities between the Finance Commission and the erstwhile Planning Commission in Federal Fiscal Transfers. 4. Table 45.1 Finance Commissions appointed. So far, Finance Commission Chairman appointed in submitted report in period of implementation of report. First, K.C. Neogi 1951, 1952, 1952 57. Second, K. Santanam 1956, 1957, 1957 62. Third, A.K. Chanda 1960, 1961, 1962 66. Fourth, Dr. P. V. Rajmanna 1964, 1965, 1966 69. Fifth, Mahavir Tyagi 1968, 1969, 1969 74. Sixth, Brahmananda Reddy 1972, 1973, 1974 79. Seventh, J. M. Shalak 1977, 1978, 1979 84. Eighth, Y. B. Chavan 1982, 1984, 1984 89. Ninth, N.K.P. Salve 1987, 1989, 1989 95. 10th, K.C. Pant 1992, 1994, 1995 2000.
11
a.m. Khusro 1998, 2000 2000 2005. 12th, Dr. C. Rangarajan 2002 2004 2005 2010. 13th, Dr. Vijay Kelkar 2007, 2009 2010 2015. 14th, Y.V. Reddy 2013, 2014 2015 2020. Table 45.2 Articles related to Finance Commission at a glance. Article No. Subject Matter 280. Finance Commission 281. Recommendations of the Finance Commission. Notes and References. 1. Why the Finance Commission Act, 1951. To this function was added by the 73rd and 74th Constitutional Amendment Acts of 1992, which have granted constitutional status and protection on the panchayats and the municipalities respectively. 3D Basu, Introduction to the Constitution of India, Wadhwa 19th edition, 2001, p. 331. 4 Report of the 4th Finance Commission, New Delhi, Government of India, 1965, p. 8890.
National
Commission for SCs. The National Commission for Scheduled Castes, SCs, is a constitutional body in the sense that it is directly established by Article 338 of the Constitution 1. On the other hand, the other national commissions like the National Commission for Women, 1992, the National Commission for Minorities, 1993, the National Commission for Backward Classes, 1993, the National Human Rights Commission, 1993, and the National Commission for Protection of Child Rights, 2007, are statutory bodies in the T sense that they are established by Acts of the Parliament 2. Evolution of the Commission. Originally, Article 338 of the Constitution provided for the appointment of a special officer for scheduled castes, SCs, and scheduled tribes, STs, to investigate all matters relating to the constitutional safeguards for the SCs and STs and to report to the President on their working. 3. He was designated as the Commissioner for SCs and STs and assigned the said duty. In 1978, the government, through a resolution, set up a non-statutory multi-member commission for SCs and STs. The office of Commissioner for SCs and STs also continued to exist. In 1987, the government, through another resolution, modified the functions of the commission and renamed it as the National Commission for
SCs and
STs 4. Later, the 65th Constitutional Amendment Act of 1905 provided for the establishment of a high-level multi-member National Commission for SCs and STs in the place of a single special officer for SCs and STs. This constitutional body replaced the Commissioner for SCs and STs as well as the commission set up under the resolution of 1987. Again, the 89th Constitutional Amendment Act of 2036 bifurcated the combined National Commission for SCs and STs into 2 separate bodies, namely, National Commission for Scheduled Castes, under Article 338, and National Commission for Scheduled Tribes, under Article 338-A. The separate National Commission for SCs came into existence in 2004. It consists of a chairperson, a vice-chairperson and 3 other members. They are appointed by the President by warrant under his hand and seal. Their conditions of service and tenure of office are also determined by the President. 7. Functions of the Commission. The functions of the Commission are: A. To investigate and monitor all matters relating to the constitutional and other legal safeguards for the SCs and to evaluate their working. B. To inquire into specific complaints with respect to the deprivation of rights and safeguards of the SCs. C. To participate and advise on the planning process of socio-economic development of the SCs and to evaluate the progress of their development under the Union or a state. D. To present to the President, annually and at such other times as it may deem fit, reports upon the working of those safeguards. E. To make recommendations as to the measures that should be taken by the Union or a state for the effective implementation of those safeguards and other measures for the protection, welfare and socio-economic development of the SCs, and F. To discharge such other functions in relation to the protection, welfare and development and advancement of the SCs as the President may specify.
Report
of the Commission. The Commission presents an annual report to the President. It can also submit a report as and when it thinks necessary. The President places all such reports before the Parliament, along with a memorandum explaining the action taken on the recommendations made by the Commission. The memorandum should also contain the reasons for the non-acceptance of any of such recommendations. The President also forwards any report of the Commission pertaining to a state government to the State Governor. The governor places it before the state legislature, along with the memorandum explaining the action taken on the recommendations of the commission. The memorandum should also contain the reasons for the non-acceptance of any of such recommendations. Powers of the commission. The commission is vested with the power to regulate its own procedure. The commission, while investigating any matter or inquiring into any complaint, has all the powers of a civil court trying a suit, and in particular in respect of the following matters: a. Summoning and enforcing the attendance of any person from any part of India and examining him on oath; b. Requiring the discovery and production of any document; c.
Receiving
Evidence
on
on affidavits;
D.
d. Requisitioning any public record from any court or office; e. Issuing summons for the examination of witnesses and documents; and f. Any other matter which the President may determine. The central government and the state governments are required to consult the Commission on all major policy matters affecting the SCs. The Commission is also required to discharge similar functions with regard to the other backward classes, OBCs, and the Anglo-Indian community as it does with respect to the SCs. In other words, the Commission has to investigate all matters relating to the constitutional and other legal safeguards for the OBCs and the Anglo-Indian community and report to the President upon their working it.
Notes and references.
1. Article 338 is contained in Part 16 entitled as Special Provisions Relating to Certain Classes. 2. The years in the bracket indicate the years of their establishment. 3. The constitutional safeguards for the SCs and STs are explained in Chapter 66.
4.
It was made as a national level advisory body to advise the government on broad policy issues and levels of development of SCs and STs. 5. The Act came into force on 12 March 1992. 6. The Act came into force on 19 February 2004. 7. Under the rules, they hold office for a term of 3 years. 8. Clause 10 of Article 338 reads as follows: In this article, references to the scheduled castes shall be construed as including references to such other backward classes as the President may, on receipt of the report of a commission appointed under Clause 1 of Article 340 by order specify, and also to the Anglo-Indian community.
National Commission for
SCs,
STs,
i.e. the National Commission for Scheduled Castes, SC.